trading as Masaku East and South Station, Shell and Malindi, Kenya Limited.
Yes.
For delivery of judgment civil appeal number 42 of 2017, International Center of Infant Psychology.
Our judgment again will be delivered on 4th of May, 9 o'clock.
Much more. The Kenya National Union of Teachers and two others for the Teacher Service Commission. 2017, Energy Regulatory Commission for Shillings Kenya Limited and another.
Yes. That it be and is hereby dismissed with costs.
The form of Milton, Harrison and Martin. Focus. Delivery of judgment, civil appeal number 253 of 2013, Investments Kivinci and Company Advocate for the Fidelity Bank Limited.
Mohammed was here first to be given the appellant. There was the language. Consequently, and in conclusion, we hereby quash the conviction for the offense of murder and set aside the death sentence imposed upon the appellant. We substitute, therefore, conviction for the offense of manslaughter contrary to Section 202 as read with Section 205 of the Penal Code and sentence the appellant to serve a prison term of 20
Mohammed and 3 others.
On the right and responsible for first and second responders.
Judge and affirm and secure indeed a compelling basis for making the categorical factual conclusion at paragraph 198 of his judgment that, quote, in my view, the first respondent failed to show that he had actually obtained the 2 degrees from Kampala University. The petitioners proved his case to the required standard. The source and how the 2 degrees came into being are facts that were in the special knowledge of the first respondent. In view of the uncontroverted evidence on record, they are not what they purport to be, end of quote. We think that given the facts as we have established before him, the learned judge properly distinguished the case of Janet Ndogo Ekimbo Mete versus IEBC on the basis that in the latter case, the respondent had undertaken the studies leading to the conferment of the subject degree and was only waiting to graduate so that he was academically qualified, while in the case at hand there was no evidence that the appellant did undertake the academic studies at the university. There really can be no difficulty, therefore, in arriving at the conclusion that the learned judge was justified on the evidence and the law to hold and find that the appellant was not legally cleared to vie for the position of governor, as he did not satisfy the qualification criteria set out in Section 22(2) of the Elections Act. He was not eligible to contest, and the charge to that finding and conclusion fails, as it is bound to. The consequence of that finding is obvious: the election of the appellant and to be invalidated. A person who is not qualified to vie for a particular seat cannot hold on to his forced victory by pointing to the margin of his vote vis-a-vis his competitors. He ought not to have been in the race in the first place, and the alleged victory is a distortion of reality and a subversion of the electoral process. In this respect, we agree with the persuasive decision of the Supreme Court of India in Mailembam Prithviraj Singh versus Pukrem and Asal Hussain versus Rajiv Gandhi. The effect of our upholding of the learned judge on the question of the appellant's lack of academic qualification is that it renders our examination of the other grounds of appeal quite superfluous. The reason is quite simple. Whether the election was properly conducted or not, or was fraught with irregularities or so grave a character that they affected not only the credibility of the election but the results of the election as well so that no reasonable tribunal can uphold them, as the learned judge found, it must stand invalidated because the person declaring the winner, namely the appellant, was not qualified to vie and was not validly elected. That being the inescapable adjudicative result, we do not see any utility in embarking on a forensic examination of the other grounds in pursuit of a merely didactic of academic aim. In the result, the appeal before us is devoid of merit and is dismissed with cause to the first and second respondents. The cross-appeal by IEBC and the returning officer must also perforce stand dismissed, but with no orders as to costs. Orders accordingly.
We've just won the appeal case that was filed after we won the first petition. The concurrence by the appeal court of the decision of the High Court has indeed vindicated everything that we have alleged, that there were no elections, valid elections that were held for the seat of governor in Wajir County on the 8th of August 2017. I think what we now need is to expeditiously conduct a free, fair, credible and verifiable election in Wajir County so that the will of the people of Wajir County prevails, and so that we need a closure, we get the closure that we need to ensure that activities, operations and development within the county do not stall. So it is our call to IEBC to expeditiously conduct an election within the framework of the Constitution and the election laws of this country. And we ask our supporters and the good people of Wajir County to maintain peace. This is a legal process. It is a constitutional right that when elections are stolen, when elections are conducted improperly, then we go to the courts to seek redress and await for a repeat election in line with the Constitution. So we want them to maintain peace and order until we get to that day. Thank you.
Or your opponent should be disqualified totally from the race?
And that is the judgment of the court. So what we're asking is a fresh election where candidates who meet the prerequisites and the criteria for clearance are cleared, and a fair and credible election is held. Because this election was annulled on both grounds. That one, the returned candidate was not validly cleared, and that two, the election was not verifiable on account of the illegalities and the irregularities. So what we're asking is IEBC to start the process afresh, carry out a fresh nomination of candidates, and two, hold a free and fair election that reflects the will of the people of Wajir.
With the current situation facing IEBC,
I think that's not for us. The IEBC is a constitutional office. There can be a vacuum on it. Elections must be conducted. If there's a by-election, then it must be conducted. That's for someone else to answer, I suppose.